Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for argument this morning. First up is 23-1379, 23-2059, Chavez versus Garland. Mr. Winograd, good to see you again.
Thank you, Chief Judge Diaz, and may it please the court. The question in this case is whether petty larceny in Virginia is a crime involving moral turpitude, or CIMT. We have raised two arguments why it is not, and the court should rule in our favor if it agrees with either one. First, defendants can be convicted for acting with a mens rea of negligence by taking property that they sincerely but unreasonably believed was abandoned or that they were otherwise entitled to take. And second, defendants can be convicted for taking property of de minimis value, including property worth even less than a penny. Unless the court prefers otherwise, I'll address the arguments in that order. To obtain a conviction for larceny, Virginia prosecutors must establish that the defendant had an intent to steal. We don't dispute that. But in at least 4 cases, the Virginia Court of Appeals has held that a defendant can have an intent to steal even if he subjectively believed the property in question was abandoned. According to those decisions, a subjective belief that the property was abandoned is only a defense to larceny and can only negate the intent to steal if that belief was reasonable, all of which means that defendants can be convicted of larceny in Virginia for negligently taking property that they sincerely but unreasonably believed they were entitled to take.
Has any Virginia court actually expressly said that?
Yes, I believe so. I think Welch certainly proves our point. That was the case in which a woman took an unattended tablet that she found inside a Sheetz convenience store. And we submitted the trial transcript with a reply brief. And if you go to pages 42 and 43 of the addendum, the trial judge specifically said that a defendant can only succeed on an abandonment defense if the belief was both subjectively honest and objectively reasonable.
Go ahead. No.
How do I square that with what strikes me as a much more nuanced analysis by the Court of Appeals itself, which distinguishes between two questions? One, whether you're entitled to a jury instruction, which I agree, they clearly say it has to be objectively reasonable to get a jury instruction, versus sufficiency of the evidence, where when the Welch Court is talking about that, it seems much more to be saying a fact finder could reasonably conclude that she did not in fact believe it was hers, because as a matter of fact, the fact finder could find you probably don't think there's an abandoned iPad in the middle of a gas station. And then just devastatingly for that defendant, a person who believes something is theirs probably doesn't put a napkin over it. Right. That seems wildly inconsistent with this objectively honest belief that you think it's yours.
Sure. A few responses to that, Your Honor. One, Welch says, we read it as a statement of law, that a defendant charged with larceny can assert an honest belief that the property she is charged with stealing was abandoned, so long as the evidence establishes a reasonable basis for her to have such a belief. Then on the distinction between the jury instruction and the ultimate factual question, we think that's really a distinction without a difference.
So, I'm sorry to interrupt, but so the first half of what you said with respect to the reasonable belief makes sense. But ultimately, a jury, or in this case, the judge, has to make it a finding that there was actually a specific intent to steal. Nothing to do with reasonableness. They just didn't believe her, right, and convicted her.
Well, it's both. We don't dispute that a defendant, the first hurdle to get over is that they had a subjectively honest belief. But even if they do have a subjectively honest belief, our reading of these decisions is that they also the government has to disprove that that belief was objectively reasonable.
But that means affirmatively prove that your client, not your client, but the defendant had the specific intent to steal.
Well, they don't say, the court's never said specific intent. There has to be an intent to steal.
Right.
But I think that just raises the question of what is sufficient to satisfy that intent. And even though an intent to steal, we would generally think would require specific intent, the Virginia Court of Appeals, as we read those opinions, has said, no, it's not specific intent. It's even if someone subjectively believes the property is abandoned, that belief is only sufficient if that belief was objectively reasonable.
So what do you do with footnote 3 of Welch, right? So footnote 3 in Welch tells us that the critical finding under our case law is whether they had a good faith belief, period. The reasonable basis language, the court explains, is asking about whether there's sufficient evidence to allow an instruction to the jury, right? So the jury's question is just whether there was a good faith belief. Now, there might be some evidentiary challenges. You don't get an instruction unless you put forward evidence, right? But that's not what the jury's finding is. The jury has to find that your client intended to steal. And the way to negate that is to say, I didn't intend to steal it because I had a good faith belief it was mine, even if that belief was crazy.
Sure. A few responses. One, we think Welch said that the good faith belief was the critical finding because that's always the threshold question. You first have to look at whether there even is a subjective
But it then
belief.
goes on to explain what the reasonable basis language goes to is whether there's sufficient evidence on the instruction. And the jury instruction issue is a different question for us. We're asking whether the elements require this or not.
Welch itself was a bench trial. There were no jury instructions, and the judge nonetheless considered the objective reasonableness of the defendant's belief.
Of course he did, because that's evidence. This is what the court is saying. I mean, I'm just literally repeating what they say. That's evidence of whether the belief was in good faith. I mean, one piece of evidence that the trier of fact can consider in determining whether your belief is in good faith is whether it's reasonable or not. It's not dispositive of that question, right? But it's, you don't disagree that it's evidence of whether
certainly.
you have a good faith belief.
That what you're claiming you believed seems deeply implausible to us, right? Like, that you could say, I'm skeptical because what you're claiming seems implausible.
Right. Well, this is what the judge specifically said in Welch.
No, but go back and understand. Do you agree with the premise, right? That whether your belief is a reasonable one is evidence of whether you have a good faith belief.
Yes, I agree with that premise, certainly, Your Honor. But I'm saying if you look at what the judge in Welch actually
You
said.
mean the trial judge?
I'm sorry, the trial
But
judge
we're not
in
talking
Welch.
about the trial judge. I'm talking about what the Court of Appeals of Virginia said in a published opinion in affirming the trial judge. And when they talk about why the evidence is sufficient above the line, I see them talking always very carefully in language of a reasonable fact finder could have concluded that she didn't actually believe it was hers. And the evidence was sufficient to permit a reasonable fact finder to
Sure,
conclude
but it also says earlier in the opinion that the claim of right defense is only available so long as the evidence establishes a reasonable basis for her to have a belief, which we read as imposing an objective requirement. And also
Is there any other, I mean, one of the things our job is to predict what the Supreme Court of Virginia would do. Is there any other Supreme Court that's abandoned the hundreds of years of precedent that requires an intent to steal for larceny? I mean, we can go back across the pond for hundreds of years. An actual intent to steal is required. Are there jurisdictions that have actually said what you are trying to pull out of Welch? That a negligent but good faith belief works?
Certainly in Hynant, that was the 1996 decision of the Virginia Court of Appeals. They
What I'm
cited a
asking,
number
has any other jurisdiction
made very clear that they've done that.
in the United States actually adopted the rule that you've suggested?
I don't know off the top of my head. My point was just that Hynant did cite a number of cases from other jurisdictions. I don't know off the top of my head whether those were the highest courts of those states or intermediate appellate courts of those states. But my ultimate point is we have 4 decisions from the Virginia Court of Appeals, which, as we read them, impose an objective reasonableness requirement on this. And
On that front, I've been trying to, I think
Yeah.
I might know, could you just quickly tell me what when you say 4 decisions, what 4 decisions you're referring to?
Hynant from 1996, Hababa from 2013, Norcraft from 2022, I believe, 2023, and Welch, the most recent one.
That's what I
from
thought. I just wanted to make
2024.
sure that I knew
Yes.
which 4 we're talking about.
Sure, and we're not aware of any, decision from the Virginia Supreme Court to specifically address this issue, but even if this court were hypothetically to certify the question to the Virginia Supreme Court and it were to overrule the Virginia Court of Appeals, then that wouldn't change the fact that on the ground, defendants have been convicted or
Have
in
been,
cases.
perhaps. Not going forward would not be, but maybe
Going
have been.
forward, yes, but it wouldn't change the facts on the ground going backwards. Now, but even if Virginia larceny does require a culpable mental state, our second argument is that petty larceny specifically would not be a CIMT because it doesn't require reprehensible conduct.
Can I ask you just a threat?
Yeah.
There was a statement in the brief that just really struck me, and there was some authority cited, and I remember finding the authority that was cited not persuasive for this point. What is your best authority for the proposition that we can consider changing social mores and deciding whether something is a crime of moral turpitude? I mean, I know we do this in the Eighth Amendment context, but that's because the Supreme Court has said that's what we do there. But
Well, historically, the board's position has always been that you look to contemporary.
yeah, I know,
moral
but like,
norms. What-
man, Loper Bright, Chevron's gone, so kind of who cares what the board thinks now, right?
Sir, well, I think this court's recent decision in Ortega Cordova, that was the one involving solicitation of prostitution, also was premised on the idea that even today there is a changing moral consensus. And I mean, if this court were to not consider
Wait, I'm sorry,
moral
say that
norms,
one more time. You think Ortega Cordova
Does what?
supports the point that we have to look at the changing social mores?
that you look at what it is that you consider contemporary social norms today. I mean, if it was otherwise, then there would be crimes like adultery and sodomy that would be crimes involving moral turpitude, because those were historically regarded as crimes involving moral turpitude.
Assuming they were
Certainly in the-
still criminalized and assuming that people were still prosecuted for doing them.
Yes, but, well, adultery is still on the books in Virginia, and it's rarely prosecuted, but
I was gonna say,
decades ago.
can you identify the last time someone was prosecuted for adultery in Virginia?
No, but the point is that I mean, I'm certainly not aware of any court that has said that when we consider contemporary, that we consider whether something is reprehensible, we are stuck with the views of society as they existed early in the 20th century.
Isn't that kind of how we do statutory interpretation now?
I mean, the term crime involving moral turpitude was initially enacted in, I believe, in the late 1800s. It's been reenacted multiple times. So then you would have the threshold question of
Well, just
what year.
can I
But-
take us back at like a sort
Yeah.
of a very high level generality on this point? Like, crime of moral turpitude is famously opaque and not clear what it means, and
Mm-hmm.
maybe there would have been an argument at some point is void for vagueness, all of these things. But I mean, when I think about when people say crime of moral turpitude, stealing seems pretty close to the heartland of crime of moral turpitude. Like, if you think about what the historical understanding of a crime of moral turpitude is, stealing strikes me as pretty close to the core meaning. Like, or, you know, I used to work at the University of Virginia with like lying, cheating, and stealing. The crime, like, why are those three singled out? Because they're viewed as uniquely culpable things, lying, cheating, and stealing, right? So
Right.
it just seems like a big ask to say there's a type of stealing that isn't a crime of moral turpitude.
Well, under the categorical approach, we're looking at the least of the acts criminalized. So as a general matter, is stealing wrong? Of course, but that's the case with any crime.
Sure.
But I would just ask the court to consider
But
the
it's
many
obviously
ways.
not true for any crime. That's the whole point. The crime of moral turpitude is a subset, right?
Well-
It is, you know, lying, cheating, and stealing is a pretty good place to start, right?
Sure.
I mean, and maybe that's not sufficiently precise because it also includes things like prostitution, and so
Mm-hmm.
we can talk about other things, but it's obviously not every crime. And there are tons of regulatory crimes that we don't think
Sure.
are crimes of moral turpitude.
I should have said many crimes. But my ultimate point is there are many ways that otherwise law-abiding people steal things all the time. So almost anyone who works in an office will at some point use the printer for personal use. Shoppers at the grocery store will occasionally sample a grape from a bag whose price depends on its weight. And it's not uncommon for someone who is filling up a soda at a fountain to fill up their cup, take a sip, and then top it off. All of these things qualify as theft, but few people would consider them reprehensible or even wrong in the first place because the harm to the victim is virtually non-existent. And we recognize that courts have historically regarded petty larceny as a CIMT, but the vast majority of those decisions, we think, just provided very little in the way of analysis. And those that did relied on reasonings that we think this court should reject. So, for example, the Eighth Circuit in Bartos found that persons who commit petty larceny are not worthy of belief even under oath. And in Tillinghast, the First Circuit found that there was no distinction between petty and grand larceny because all theft was wrong in the eyes of God.
Can I ask that?
Yes.
So under your theory that, your analysis, are we and other federal courts going to be engaged in constant line drawing as to how much is too much before it becomes morally reprehensible?
Not at all. There's no line drawing required in this case because under the categorical approach, you're just looking at the least of the acts criminalized under the specific statute. So in this case, the least of the acts criminalized are stealing property worth less than a cent.
Sure. fine.
Great and larceny.
But let me just
Yeah.
give you a real easy, obvious. Like, imagine a state that has the line between like little larceny and medium larceny at $200. Is stealing $200 a crime of moral turpitude?
Yes. That is, $200 is unquestionably not de minimis.
20.
We would also say that's not de minimis.
Five.
The point is, Your Honor, even if this court had to draw a line, we would win
What's
under
the
any
answer
law.
on 5?
I'm sorry?
What, well, you didn't answer the 5 question?
Even if 5 is, we would win this case.
No, but I'm asking what your position is. Is 5,
Is $5?
is that, which side of the line do you
My point
place?
is, even if it is on that side of the
I'm asking
line.
the question, though, is do you think, under your line, is $5 sufficient or not?
Sure, because our line is 1 cent. Even if the court draws the line at 1 cent, we win. Therefore, the court doesn't have to draw a
You agree
line.
that if it was $5 or more, so this was like medium larceny instead of like something else, but $5 or more, you agree that's a crime of moral turpitude?
Again, that's not this case before the court.
And I'm
but-
asking the question.
Sure. We're happy to concede for purposes of this case that $5 would be a crime involving moral turpitude. Our point is simply that if the line is simply 1 cent, we still win.
Or
And I
less
also
than-
note,
Less than a cent even. Doesn't even have to be 1 cent.
I'm saying if the court were to draw the line at 1 cent,
Sure.
we would win.
Oh, I see.
And I would also note that I think our position is consistent with this court's decision in Martinez. That was the case that found that, that recognized that joyriding is not a crime involving moral turpitude, even though it results in a permanent deprivation of the gas that is used during the joyride. And if permanently depriving someone of a small amount of gas during a joyride doesn't involve moral turpitude, we see no principled reason
Can I
why.
just ask a question? I want
Yeah.
you can address it on rebuttal, but you
Sure.
brought up joyriding. My hypothesis on joyriding, I have no idea why joyriding isn't a crime of moral turpitude, other than because I've had cases that involve joyriding. Like, my hypothesis there is that's just some sort of historically contingent exemption for joyriding for reasons that don't honestly make a lot of sense to me, but so if you could address on rebuttal why we don't think of joyriding as just this weird historical carve-out that probably should be a crime of moral turpitude, but for some weird reason is not.
Sure. Well, I think it's because the answer is this court has held that it's not in
But
Martinez.
the BIA has also held that it's said that
Right.
it wasn't.
Right. Okay. Thank you, Your Honors.
Thank you, Mr. Winograd. It may be that we have a number of former judges who in their youth might have been engaged in some joyriding. So that's the joyriding exception.
I take the 5th.
Mr. Sines?
Good morning, Your Honors. Chief Judge Diaz, may it please the court, Rodolfo Sines for the U.S. Attorney General. This court should deny petition 231379 because petitioner's conviction qualifies as a CIMT for purposes of cancellation of removal, and it should dismiss petition 232059 because the petitioner waives any challenge to the merits of the denial of reconsideration, and the challenge to the temporary appellate immigration judge's authority is meritless. As to the CIMT issue, this court need not venture so far into the weeds to conclude that petty larceny is a CIMT. It need only look to the decades of board and circuit precedent recognizing that non-consensual takings are CIMTs when they have a special ingredient, the intent to permanently deprive.
Do you think that CIMT is a static concept that doesn't change depending on changing social mores?
It could change, Your Honor, but in this case, we have the precedent since the 40s for the board.
Well, that's the point, right? We've got to, I don't dispute the fact that there's a lot of precedent suggesting that, as my colleagues say, lying, cheating, and stealing are bad. But the question is, at what point do, if any, and this, Mr. Winograd's argument is that social mores may be changing with respect to this particular form of larceny. And the amicus brief, describes a number of examples of folks who are weighed down by economic disparity and do things that they might not otherwise do out of desperation. And the question is whether those people truly are morally reprehensible. Are they?
Well, our position would be that the justifications for a crime don't necessarily have a role in the categorical approach or in discerning whether there's been a change in mores. But if you look even at the Supreme Court's decision in DeGeorge, it dealt with a fraud crime, and the analysis that the court looked at was the manner in which it has been decided in the cases. We have a similar situation here, and just this summer, the board had an opportunity to revisit this traditional notion of theft as a CIMT and that special ingredient, and it declined to do so.
Can I ask you, so just assume that I repeat a bunch of things that Judge Richardson said to your colleague, and let's assume that I find a fair number of them fairly persuasive. Can you talk me through Peña-Pinedo? Because that's the one that actually is troubling for me, because that's the case that, this is the Supreme Court of Virginia, this is the, you can't have a claim of right defense if you rob another drug dealer of money that you think was your drug money. Why is that? Like, on the one hand, that seems obviously intuitively right to me, and the theories that the Virginia Supreme Court gives is that, like, you can't have a property interest in contraband, you can't have a property interest in the proceeds of contraband, but that's an argument why you're wrong when you believe it's yours. That's an argument why you're objectively unreasonable when you believe it's yours. But none of that necessarily responds to the argument that the defendant in that case may have, in fact, sincerely believed that it was his, right?
Correct.
And so doesn't that suggest, like, why isn't that hard to square with the notion that you cannot be, like, I actually think that's maybe their best case. Like, that seems to suggest that even a defendant who honestly believed it was his, even though he was wrong legally and objectively, unreasonably, but they smack that claim down with extreme prejudice. And there's no suggestion that it's not just that he can't get a jury instruction. They seem to suggest very strongly this defense is invalid as a matter of law. And how do you square that with the notion that this can't be violated if you have a,
Yes.
Go ahead.
I guess our position would be that in that case, it cites this Pierce case, which is a Supreme Court of Virginia case, which kind of is the underpinning for a lot of these precedents, and it talks about the defense as coming in as a matter of evidence, as this court was alluding to earlier. So our position would be that it is something of an evidentiary matter rather than a requirement that needs to be shown. And
I mean, I guess I would say if I was a defense attorney or if I was a trial judge who read that case and a defense attorney got up and said the following, you may not like the fact that my client is a drug dealer who is robbing another drug dealer. The judge is going to instruct you that as a legal matter, he was wrong in claiming that he believed it was his. You might also think it's crazy for anyone to actually believe they can own drug proceeds, but he took the stand and he said he believed it's his. And if you believed him when he said that, you must acquit him. I would be very reluctant to say that as a defense lawyer, having read this case, because based on the Supreme Court of Virginia's decision, I think I am about to get in big, big trouble. I think the government's going to object. I think it's going to get sustained, and I think I'm going to get yelled at. And if I'm the trial judge, I'd probably think I should sustain that objection, because the Supreme Court of Virginia said this does not matter. But that suggests to me that there are at least some defendants who could honestly believe it's theirs and still be guilty. Now, maybe that's a weird historical exception for contraband, but that's the only thing I've been able to come up with.
But it ultimately comes down to whether the person had the specific intent or not. So if, as an evidentiary matter, they reasonably believed or didn't.
But what I'm telling you is I don't read that decision as saying the Supreme Court of Virginia agrees with you on that question. I read that decision as saying the Supreme Court of Virginia thinks that is not a defense, even if you honestly believe the contraband belongs to you.
But isn't that because it's all based on this fiction that you can't have a property interest in contraband? Right? I mean, it seems like to me the oddity here is this is like a public policy exception, right, for contraband. There's no, like, principle in the common law that you cannot, right? This is just an exception for contraband. And so I took that to be one of these exceptions. Maybe, you know, Toby's joyriding is one too, but that it's an exception for public policy reasons that's sort of distinct from the broader principle of law.
Correct, Your Honor. We would agree with that position. And I think it's important to also liken this case to the Granados case, which this court decided. And there, the bases, among others, was distinguishing the Martin case, in part because no case law had suggested that, in Martin, there had been case law that suggested that the defense may impact whether or not it is ultimately negligent mental state. But here, we have no such precedent. There, the court was relying on the Bain case in Maryland, which outright, irrespective of the defense, recognized that negligence could be encompassed within the general intent. Here we have no such case that says after applying or not applying the defense that the petitioner was in fact acting negligently and that it changed the specific intent that's otherwise required for the crime. The other important thing to know from Granados that's we feel is persuasive is that there the court said that the defense only underscored the the specific intent, or the intent requirement in that case. And that was because it negated an element of the crime. We have that same situation here. All of the cases that the parties cite expressly acknowledge that this defense could ultimately negate the element. So it goes back to this idea that we ultimately care about whether or not the specific intent is there or not.
Mr. Winograd listed a number of examples of folks doing things during the course of a day, stealing a grape, or taking a grape, office supplies from an office, as the kinds of things that society would not necessarily think, even if wrong in some abstract, broad way, wouldn't think it would be morally reprehensible. Does that matter for purposes of our analysis, or do you distinguish that in any way?
It doesn't matter based on the decades of precedent, but even if we take one of those examples, taking grapes from the supermarket, there are situations where a person would not necessarily be committing a CIMT, but that's because there's an entitlement to taking that property. If a person is a customer, it might be a part of the understanding that they take ketchup packets, but perhaps a person who's coming in with no desire to purchase anything doesn't have that same entitlement. So it just underscores that all we care about is the intent. That's been the special ingredient all along, and it continues to be to this day. I do want to quickly address the Martinez decision and joyriding. The court didn't hold that joyriding is not a CIMT, even though it permanently deprives a victim of gasoline. It was addressing a separate legal question about the expanded definition of CIMT thefts, i.e., where the person intends to deprive and substantially erode the property. And it didn't recognize that this court has to look at a threshold for the value of the property taken. It was looking at value as a factor for discerning whether the deprivation had been substantial enough. So it even in that context for theft, there has never been a requirement that we look at the value of the property taken. What matters is ultimately this intent.
Can I just go back to rephrase slightly differently the pain? So let us imagine the following, that if a Virginia court, or if we were to conclude a Virginia court would, in situations where the defendant did not have an objectively reasonable belief, and thus will not give the jury instruction, does your argument depend on the claim that under Virginia law, defense counsel can still argue, based on the general definition of intent to steal, and this would be a correct statement of the law. Like, my client took the stand, she told you she thought it was hers. I don't care. You may think it sounds fishy, you may think it sounds weird, you may think she's deeply weird and she has a lot of quirky beliefs about a lot of things, but if you believed her, when I say believed her, if you believe that she was telling the truth when she said that, you must acquit her, no matter how insane you think her belief is. Does your ability to prevail depend on the idea that the Virginia courts would let you do that and say that's a legally correct argument?
No, Your Honor, because ultimately what we care about is the outcome as to the intent. So
Well,
going
hold on,
back
but if I
to
can't get a jury instruction and I can't make an argument, we're probably not going to get the outcome.
When you say no, there's a compound
Sorry.
question, and so I'm not sure
Sure.
which one you were saying no to. Right, so he gave you a premise. Could you do that as a defense lawyer? Question one. Question two, does your argument depend on that answer? Question two, you said no, but I don't know which one you said no to.
Sure.
My bad.
So can you start with the first question, which is defense lawyer stands up and says, my client's deeply weird. She believes crazy things, but she really believes them. And if you believe that she's telling you the truth, then she had no intent to steal. That's a legitimate argument that the Virginia courts would permit.
So in terms of the premise, our position would be that it's not something necessarily that matters for purposes of the ultimate specific intent inquiry.
I know, but answer the first question first. Would a Virginia court permit that? under the case law that we've read, we've talked about all these cases, and bracket for a minute the cases that seem to be based on the public policy of not helping criminals, right? But in any other property case, right? Any other piece of property that's not contraband, would the defense lawyer be permitted, based on your read of these cases, to make that argument? Forget about a jury instruction, but stand up and say, there's no intent to steal because my client has an idiosyncratic but real belief that this was granted to him by, whatever, some crazy thing.
Apologies, I think I misunderstood the question initially. So yes, the defense counsel could be able to raise that argument.
And the second question is, do you believe that your ability to win this case depends on that being the correct answer under Virginia law?
No, Your Honor, because ultimately, this case is much like Granados in that we don't need to look at what the defense impacts if it doesn't change the ultimate mental state that is required.
But
as
how would
an
it not
element.
change the ultimate mental state? Because in the hypo Judge Richardson and I just gave you, this defendant subjectively believes it's hers. That seems like an important mental state, that she subjectively believes it's really hers. How does that not change the ultimate mental state?
Because it's evidence that goes to whether or not the person specifically intended to take or deprive.
Yeah, well, you can't intend to take someone else's property that you believe is yours. I don't know how I can intend to take your property if I believe that the property in question is mine. Now, I might be wrong about that it's my property, not yours, but I don't know how I can intend to take your property if, again, an infallible lie detector test would reveal that I honestly believe it's mine.
But if that is the case as an evidentiary matter, the defendant doesn't have the requisite mental state.
Yes. I agree. Okay.
So what we care about actually is the situation where the defense doesn't work and whether or not that changes the mental state. So if the person doesn't act with the objectively reasonable belief, does that ultimately change that the person has to have acted with the specific intent? And our position is no, because ultimately we still have to show the same thing, that the person did or didn't intend. If the defense fails, then the person had the intent.
Can I ask you how you square your statement that we categorically don't consider affirmative defenses with the very clear fact that in Martin we did?
Sure. So in Martin, the court relied on state case law to conclude that the offense ultimately requires negligence. It cited the Bain case. And the Bain case,
But we called it an affirmative defense in Martin, right?
I believe so, Your Honor. I'd
Okay,
have
so
to
I just
double
don't know
check.
how we can say we categorically don't consider affirmative defenses if there's a case of ours that's, and I know Granados says that we don't, but Granados came after Martin, so I don't know how Granados can say we categorically don't consider them after Martin said we do sometimes. At least sometimes. We didn't say we always do, but the statement that we never do seems like it can't be possibly right in light of Martin, because in Martin we considered what we described as an affirmative defense.
Sure, Your Honor. And I'm not aware of any circuit precedent where they have said that it doesn't, I'm sorry, any circuit precedent that says that we can't consider the defense.
What is the difference in semantics are hard sometimes, particularly when we're talking about state laws and the like. The difference in your mind, between a defense and an affirmative defense is what? Like when we use the term affirmative defense,
Sure.
what do we mean by that that's distinct from, just a defense that defeats an element?
And when you say, what do we mean, you're speaking?
What do you think, right? So, there's a little bit of a challenge of semantics, right? And you can draw a line between a defense, that is something that negates an element, and an affirmative defense, which is something that protects you from liability, even if the elements are met, right?
Sure. Yes.
That might be a line to draw between those two, a defense and an affirmative defense.
We would agree.
But my read of state case law is that is not the uniformly adopted understanding of those terms.
Correct, Your Honor. There are instances in the state cases that call it an affirmative defense. There are others that call it the claim of right defense. And so sometimes the courts below have sometimes meant one when
And your point is, whatever the semantics, what we don't do is consider the first option, which is something that would defeat the element. And maybe sometimes we call that affirmative defense, sometimes we call it a defense. But that, where you're defeating an element, that's a separate inquiry than where, like self-defense, which is, I did those things, but
Right.
there's an affirmative story.
Correct, Your Honor. Those things would be different. But it wouldn't ultimately be dispositive here because, as I mentioned before, we have the absence of a state case that's showing that the mental state here changes with or without the defense. At bottom, it just negates the element, and that underscores that we have to show that that element exists or not.
Do you have anything else, Mr. Sines?
No, I would cede the rest of my time to my friend on the other side.
Thank you very much.
Thank you.
Mr. Winograd?
Thank you, Your Honors. Just to pick back up on this affirmative defense issue, we think the government's argument conflates the distinction between a true affirmative defense and what in Virginia is called a case-in-chief defense. A true affirmative defense, like insanity, can't be considered under the categorical approach because it doesn't negate an actual element of the crime.
And self-defense would be the same?
Correct. It's simply available as a matter of policy for defendants who society believes shouldn't be punished, even though they actually did commit the crime.
Duress, things like.
Correct, exactly. By contrast, a case-in-chief defense does negate an element of the crime. So I think the term affirmative defense is sometimes overused, the way the term jurisdictional is sometimes overused to refer to things that are actually claim processing rules. I think that's the same case with affirmative defenses. Now, if the only requirement to succeed on an abandoned defense in Virginia was subjective honesty, if that was truly the only requirement, then it would hinge entirely on the credibility of the defendant. And if it was purely a question of credibility, then we think it would always have to go to the jury. We don't think a judge has any discretion to say, in this case, there's no way the jury could find this particular defendant credible.
But judges
Therefore,
judges do get a lot of discretion about whether to give supplemental jury instructions, right?
Sure, but I don't believe on credibility. I think credibility is always a question.
No,
for the-
you're not entitled to a self-defense instruction just because you say you want a self-defense instruction, right? The judge usually has to find some plausible basis on which a reasonable jury could find conceivably this was self-defense.
Right, well, my
you're not
understand-
entitled. Let's just take the other ones. You're not entitled to an insanity defense instruction just because you want one, or a duress instruction just because you that's pretty normal. That just because you want an instruction doesn't mean the trial judge has to give it to you if there's no evidentiary basis for it.
Sure, but I believe at least with self-defense that there is an objective component to that. And the reason that instruction can be denied is if no reasonable person in that position would feel the need to exercise self-defense. And so we think the same is here.
And the whole point of this, that any instruction about this is duplicative of the element anyway? Because this is Judge Hyten's point, right? Instruction or no instruction. If you stand up and say, if you believe my client, they have a belief that it's theirs, that by definition defeats an intent to steal. And so I actually don't understand the jury issue as being relevant, jury instruction issue as being relevant to this at all. There's an instruction that requires intent to steal, right? That's sufficient for the defense to make the argument. The good faith defense is like a euphemism, right? It just defeats the element. You already have the element, and so the defense is entitled to make that argument. If Virginia wants to provide a supplement to that instruction, that seems fine, but irrelevant to my calculus.
Sure. Well,
Why is that not right?
Well, I think ultimately the jury instruction issue is a red herring because Welch was a bench trial. And if objective reasonableness wasn't supposed to be considered at all, then I think the Virginia Court of Appeals would have said, this is a bench trial.
No, but
the judge shouldn't have even
Welch,
considered it.
But the whole point is the judge is absolutely supposed to consider it in Welch. The trial judge is, because it is evidence of whether the belief was in good faith or not.
Well, the trial judge specifically said, my understanding of the law is that this is a two-part test that requires both subjective honesty and objective reasonableness. If that wasn't correct, I would think that the Virginia Court of Appeals would have used the decision as occasion to specifically say that objective reasonableness is not a standalone requirement, as the trial judge appeared to
And that just turns
treat
on
it.
whether we think footnote 3 does that or not.
Correct. Now, Just very, very briefly, I just want to make clear, all of our hypotheticals involving grapes, ketchup packets and whatnot, those are situations where the person isn't entitled to it, or a person is simply doing it out of greed. And our point is simply that, someone who samples a grape that they're not otherwise entitled to take, or who takes a sip from a soda that they're not otherwise entitled to take, the harm is so de minimis that it simply doesn't rise to the level of moral turpitude.
Thank you, Mr. Winograd. Thank you. I want to thank both counsel for their excellent arguments this morning. We'll come down and greet you and move on to our second case. Our second case is 24-1293, Moshuris versus City of North Myrtle Beach. Mr. McPhail? Oh, I'm sorry.
That's okay.
Ms. Rath.
Good morning, and may it please the court. My name is Meredith McPhail, and I'm here on behalf of appellant. For at least half a century, the First Amendment has protected offensive speech. Despite that principle, the city of North Myrtle Beach in 2021 decided that it had a problem with offensive music. And even though there was already a generally applicable noise ordinance, the city passed another stricter set of volume limitations on 3 categories of speech it didn't like: profane noise, vulgar noise, and obscene noise. The ordinance included definitions for each category, with the obscene noise being defined modeled after the Supreme Court's definition of obscenity in Miller. Plaintiff, who owns a bar in North Myrtle Beach, sued under the First and 14th Amendments. And the question before the court today is whether the vulgarity provision, which imposes stricter volume limits on noise that makes explicit and offensive reference to sex, male genitalia, female genitalia, or bodily functions, violates the First Amendment. Because the vulgarity provision reaches protected speech, cannot survive strict scrutiny, and is overbroad, it must be enjoined. I welcome the court's questions.
And is that notwithstanding the fact that the district court judges seem to think that vulgarity was subsumed within the broader definition of obscenity? If that read literally, that would suggest that your client would suffer no indignity or harm, but assuming that town officials were faithful to that application, right? So why are we here?
Yes, sir. The crux of the issue is chill, which as a matter of constitutional law is a serious harm suffered by both plaintiff and others in North Myrtle Beach. So for example, when a resident of North Myrtle Beach looks to the ordinance, the textual definition of vulgar includes a broad swath of material that would not be obscene and is protected by the First Amendment. And this is critical in the context of this ordinance, which was passed explicitly to quiet offensive music, which necessarily has artistic value. And the core concern here is that folks are not going to even come close to the line of something they think is vulgar for fear not only of a fine, but also of jail time, which is a possibility under this ordinance.
Is the right way of thinking about this a question of whether, given sort of the potential need for constitutional avoidance, the vulgarity provision could plausibly be read, however language we want to use there for avoidance, but whether it could plausibly be read in such a way? Do you agree that's the right inquiry that we're asking?
I think that that's part of it. I think that's part of the inquiry we're looking at. But
And so help me understand, like, help me assume for a minute that I thought you'd probably agree, but assume for a minute that is the sort of inquiry that we're asking. We look at this sort of vulgarity provision, and I totally take that you could read it to be distinct and broader than obscenity. But at least maybe there are arguments that it could be narrowed, right? We could look at the sort of context in order to avoid the sort of constitutional problems that might arise. We could think about the sort of explicit and offensive as sort of incorporating some of the pieces that we think might be missing from the Miller test. Help me understand why I shouldn't do that, right? I mean, we don't run around sort of chopping things up, right? We're trying to, give the benefit of the doubt here. And yes, it's a little bit different, but tell me why I shouldn't take that approach.
sure, I think there's two responses to that. And the first is that constitutional avoidance just does not permit a court to rewrite a statute. And that points to the second question, which is that this particular statute cannot be interpreted in a natural way that does not functionally rewrite it. And the core of that kind of requires the court to look at the specifics of Miller. And I think the
Well,
most...
isn't the core of it is it requires us to read vulgar and offense. There's a statute that says profane, vulgar, or obscene. Profane was enjoined and is just gone, but the statute as originally written says profane, vulgar, and obscene. And one of the first principles of statutory interpretation, if it says X, Y, or Z, it's that each one of those has some amount of content that is not covered by each of the others. And under that interpretation, Y and Z would mean exactly the same thing.
Yes, that's certainly one reason that constitutional avoidance is not applicable here. And I think when we
I
look...
guess another way to say it, to the extent that vulgar does literally anything at all, it is to grab some speech that is not obscene, because otherwise vulgar adds nothing to the statute.
That's exactly right. And I think that kind of gets to the core of Judge Diaz's question about why we're here, right? Why does the plaintiff care about vulgar's inclusion, and why does the city of North Myrtle Beach care about the ordinance inclusion of vulgar? And that gets to the core of what underlay this ordinance to begin with, which is offensive music. And if vulgar captures, as it must, protected speech, it serves only to chill that speech.
But why is that gonna matter here, right? Because the district court can enjoin its enforcement, but the chill, you say, comes from them reading it, right? And what we don't get a chance to do, right, is excise statute books or ordinances, right? So North Myrtle Beach can leave that on the books as long as they like. We're at least in this posture, not going to do anything about that. And so that seems to be the same problem, right? So we're relying on people to be informed, for example, on the profanity piece, right? That remains on the books, I presume, in North Myrtle Beach. And yet there's a court order, so we sort of have this fiction that people are reading our court orders, and so they understand that they can play profane music. Why wouldn't we do the same thing with respect to the vulgarity that says, yeah, if you read the words, profane is still in there, right? So too is vulgar. But, we have this fiction that they've read the district court's order and they understand that, profane's no longer any good, even though it's still there, and that vulgarity is effectively not there either because it's the same thing as obscenity.
Yeah, I think that there's independent value in the court saying that, right? And that also sending a message to...
But it said that, right? So the district court said, hey, when you see, if you read the opinion, when you see the word vulgarity, just in your mind, scratch it out and write obscenity. So it says now you cannot play obscenity, obscenity and obscenity in these sorts of ways. And all right, I get we wouldn't naturally write a statute that way, but we're doing the best we can with the tools we have.
Yeah, I think
And that doesn't seem like a crazy thing to sort of give credit to the district court for having done.
Sure, I think that certainly limiting vulgar to obscenity only is, puts us in a better place than we were before that. But I think it still doesn't necessarily solve kind of the core problem that Your Honor is getting at, which is, if it's still on the books, what's the point? And I think that
That's still the same problem with profane, right? So profane's still on the books. We just think it doesn't chill people because they're going to have read Judge Dawson's order, right? And, vulgarity is going to still be on the books, but we ought not to think that it's going to chill anybody because they've read Judge Dawson's order. And I get it's a fiction that they're reading Judge Dawson's order, but it's a fiction that we abide by, right?
Can Judge Dawson make an authoritative construction of what state law means
yes.
that's binding on the South Carolina courts?
Well, certainly it would be binding in the specific.
Because I presume any actual enforcement action is going to be brought in state court, right?
Yes. And
Of course, that actually tees up the profane problem. Well, no, if he can enjoin, yeah, so, right, that, I guess one thought I just had is if someone calls up the city of Myrtle Beach now and says, someone's playing profane, I've read the statute, this hypothetical officious citizen who reads the statute, I've read the statute, I think what they're doing is profane, they're like, yeah, so there's a court order saying we can't actually enforce that. And then you call up and say vulgar. It's like, well, we can, good news, bad news, citizen, we can enforce the word vulgar, but vulgar doesn't mean now what the statute says vulgar means something else. I mean, that's one difference, right, I suppose.
yes, that the court's order did specifically say profane is invalid, but kind of construed the vulgarity provision in a less definitive way necessarily based on the reading. But I think if we zoom way out, what is the core of what's happening here is that the city of North Myrtle Beach is trying to quiet offensive music, and that's just constitutionally, fundamentally problematic.
So would your answer be different here? Take the hypothetical where there are two plausible readings of vulgarity, and one of them could be obscene, and one of them would stretch just a little bit beyond it. It's a different definition than what we have here, maybe, but just accept that. In that instance, we would accept the district court's order, right, as sort of having solved this problem. I mean, that's the oddity that I'm having, right? There's I don't think it's constitutionally moot, but there's a sense in which there's no additional chilling that's taking place if we accept what the district court has done.
I think to Judge Hyten's point, there is some potential additional chill, even were someone to go, kind of read the order. But
I don't understand that. I mean, I take maybe in the phone call, it seems awkward, but it's not a whole lot different, right? To say in one, we can't enforce this one, and in this one, we can enforce this one only so far as it's obscene. I don't know. Those seem like reasonable things that a city official could say.
Sure, I think just in terms of the statutory interpretation and South Carolina's rules of statutory interpretation as applied to the ordinance, there's a strong rule against surplusage, which would say that to the degree that vulgarity and obscenity mean the same thing, that's just not how we can read the ordinance, because the city's argument functionally is we wanted to stop obscene noise, and so we put that in the ordinance. And then we wanted to stop obscene noise again, and so we put another word into the ordinance. But under the rules of statutory interpretation in South Carolina, that's just not permissible.
I mean, it's not permissible, but we have surplusage all the time, right? It's like a rule of thumb. It's not a prohibition, right?
It's certainly not an explicit prohibition, but I think this is a, relatively black and white case where the city is saying that we have two different terms that functionally overlap. So if we're looking at the Venn diagram under the
But I thought, and then I want to go to the chief. Sorry, I didn't mean to
No, go
interrupt, Chief. But we think about the rule of surplusage as a canon that helps us understand what the legislative body was doing, right? And so because it's a sense that the legislature wouldn't say obscenity and obscenity. But it's odd to apply that in a context when we're rewriting, in essence, the statute, right? So it's not, I don't have any doubt that the legislature here intended vulgarity to cover something other than obscenity, right? That's totally fair. But what we were doing here is, by constitutional avoidance, at least in theory, adopting a plausible reading that does create surplusage, but it doesn't violate the canon, because the canon is about understanding the legislature. We've sort of like butchered the statute. That's our fault, or, you know, the court's fault.
Certainly, I think, you know, when we look at just what's happening on the ground and why we're here fundamentally, it's that the city of North Myrtle Beach said, we don't want offensive music going on. And so we actually know exactly what the intent of the legislature was in the city of North Myrtle Beach, and it was to quiet protected speech. I mean, there's statements by city officials to that effect that said, we have heard that citizens are upset about offensive music, and we're gonna see what we can do about it. And this is what they did about it.
But we don't look at sort of subjective belief in applying constitutional avoidance, right?
Sure.
So Judge Richardson mentioned the fact that we're here simply to decide the issue before us. We can't blue pencil the ordinance, you know, that kind of stuff, because that's not the issue before us. But you represent an organization that's not no stranger to these types of issues. What's been your experience with respect to cases where the court does decide that some or all of a portion of an ordinance is unconstitutional? How does a municipality typically respond to that?
Sure. Well, certainly I'm here on behalf of the plaintiff, who is the owner of the city, or owner of a bar in the city of North Myrtle Beach. But oftentimes what a city or municipality will do will be to change the ordinance to be in compliance with the Constitution. I think that would be the ideal outcome in this case, and I think a strong ruling from this court would certainly move us toward that resolution.
Can I ask a different question maybe, and I'll let you sit down? So if we agreed with you that the district court adopted a wholly implausible reading of the statute in order to avoid the constitutional question, and that was an error, why do you think we should go beyond that and address the scrutiny question, sort of the evidentiary questions? I mean, I know y'all briefed all of this, and I appreciate it. I'm not trying to knock that. But it's a little unusual, because if we agreed with you at step one, then we would be doing, as an initial matter, sort of this evidentiary question about what is the government's interest? Is it substantial? How much evidence that they provided? We've got this whole line of cases about what's evidence in the legislative record, about the consideration or attempts to use alternatives that comes out of PETA. Might not be right, but it seems like a rule that we have. That seems really evidentiary to me. Tell me why we should go that step instead of, if we agree with you, vacate that part of the order and remand for further consideration.
Certainly. So the district court did do that kind of evidentiary work on the profanity provision, and the city has not articulated any reason why the vulgarity provision would have a different compelling interest or should be differently narrowly tailored. And so I think the district court's ruling on profanity, which the same justifications were given, the same ordinance applies, would largely apply, wholly apply to the vulgarity provision in this case.
Thank you, Ms. McPhail. Mr. Manos?
Thank you, Chief Judge, Your Honors. May it please the court, Marcus Manis, Maynard Nexon, for the appellees, City of North Myrtle Beach and its police chief. The purpose of an ordinance or a statute of any type is to give notice to persons of what's illegal. The Miller definition of obscenities in the first section, frankly, is a difficult thing to read. Vulgarity, as it's been applied by the FCC and many other federal courts, is a stand-in that helps people understand.
No, it's not. Vulgarity is applied by the FCC. It is common ground, goes way beyond things that are legally obscene. There's all kinds of things that are vulgar, as the FCC uses the term, that are not obscene legally. Right?
Yes, Your Honor.
Okay.
But as defined in this ordinance, explicit, offensive, sexual acts, not nudity, not other things, bodily functions, and genitalia. it fits in, as the district court determined.
But
into
it
the
obviously doesn't, because there's no carve-out for things with serious artistic literary value. Like, let me give you here's my obvious example. There is a recent song by Cardi B and Megan Thee Stallion that strikes me as transparently vulgar under this statute and obviously not obscene under Miller. It strikes me as blindingly obvious, both of these things. That song is obviously vulgar, as this defines vulgar, and it's obviously not legally obscene. And if you wanted to say
Can
about
we just
that,
make the second part of that hypothetical? I'm not going to accept that.
okay,
it's not
fine,
obscene.
fine. Every single song that Two Live Crew ever produced was vulgar under this ordinance, but is not legally obscene, as held by the 11th Circuit in the case where someone tried to prosecute those guys for obscenity. So it seems obvious that vulgar to me is broader than obscenity, if for no other reason than that obscenity, like Miller, has a carve-out for things that have serious artistic, literary, or other value, and the definition of vulgar does not.
Your Honor is correct. It is not explicitly stated in the definition of vulgar. The application of the statute would be consistent with Miller because of the ruling of the district court.
But
You don't,
go ahead.
so, you're not here on a cross appeal, so you don't necessarily, what's your position? Do you think Judge Dawson got that right?
Your Honor, we believe he did, but we also believe that vulgarity in this context
Means something more
could withstand a challenge on its own.
on its own?
This is
Okay.
a broadcast, not just of music, but of any line. It is set in such a way only to prevent it from going into the public right-of-way and into areas that are adjacent to it. If
How
you
is
look
that
at
any
the-
different from the jacket in Cohen? That was a guy walking around a public courthouse wearing a jacket that had, the words that it had on it. Like, that was in a public place, and the defendant in Cohen said, like, there might be some children or some vulnerable, women and children, because this was the 60s, and they may have said something like that in that opinion. But, like, my point is, the court was like, yeah, that could happen. Don't go in public courthouse. If you are really so concerned about never seeing a jacket that says words the F the draft, don't go into a courthouse. That's what you've got to do.
And partially, Your Honor, as the Supreme Court pointed out in Hustler, even vulgar speech is not entitled to complete protection.
Totally agree.
In certain circumstances. Here, there's no political context, which makes a big difference with Cohen when you think about F the draft. The whole idea behind that was there was a political message that was being given about whether the country should be involved in war, about whether people should be made to participate in those wars.
But under this definition of vulgarity, that doesn't matter even a little bit, because the fact that that was an anti-war message would make no difference under this ordinance's definition of vulgarity.
The time and place and the context, Your Honor.
I
here-
thought your answer to that would have to be, I'm not sure it's a good answer, but I thought your answer to that would have to be, that's because it wouldn't fall within the offensive qualifier, right? That political speech is by definition not offensive speech, right? That we live in a world where if you're engaging in debate about the ideas, and even in saying F the draft, I mean, that's a debate about the ideas, that could not be offensive, right? I mean, otherwise, I don't understand your argument at all. So is that the point, that we've got to read offensive to, in some sense, sort of adopt this, lacks any serious merit line?
Your Honor, it adopts the contemporary standard of offensive by its nature, by using the word, and that's correct. Political debate is accepted today throughout, even in the city of North Myrtle Beach in South Carolina, to include things that would otherwise disturb us.
So
But it's about politics. It's about something.
I
that's-
get that for the politics. The problem is, it seems like to me offensive is also, like, I think offensive probably solves the politics problem for you, or at least could solve the politics problem for you. What it doesn't solve is the things that are offensive, that address bodily functions that are not sexual, right? And we can think about what those are, but we can imagine things that are explicit and offensive involving bodily functions that are not sexual. And those strike me as the category that most obviously is vulgar, but not obscene.
Your Honor, I think if you look at the line of cases from Pacifica, and admittedly, as Judge Heitens has pointed out, when you start dealing with the FCC, there's something different. You're talking about broadcasts of speech
into people's houses. And the whole theory of those cases is you can't really avoid them, and maybe you can't, like, I was just about to ask you, I'm going to tell you in advance, I'm not going to find a persuasive a case that's about the FCC. What is your best case for the proposition that the government has an interest in protecting children from non-obscene but age-inappropriate material, not in their own homes, not in school, when they are out in the world in public? What case says the government has an interest in protecting children from vulgar but non-obscene speech when they're out in public, not in their homes, not in schools?
Your Honor, that would go back to 1949 with Kovacs, where actually the Supreme Court stated then that the broadcast into the public right-of-ways, not for something that was a political meeting, not for something that was otherwise protected, of matters that were vulgar and objectionable with children who may or may not be accompanied by their parents.
Would you
Could
agree
be-
that we've made a lot of First Amendment law since 1949 in this country?
Yes, sir, but that one has not been overruled.
Well, there's, like Cohen, for example. It's not clear to me how you can square that with Cohen.
Yeah, I understand, but it hasn't been overruled, it hasn't been rejected. It's still there. And that idea is that that type of broadcast, where children are going to be on a typical, and this is I understand that you said the FCC cases are not persuasive to you, Your Honor. However, Pacifica itself just said it's 2 o'clock in the afternoon. Kids could be listening. And that's not just necessarily in their homes. That's broadcast on car radios, that's broadcast elsewhere.
But you're making an argument that rejects just Judge Dawson's interpretation of the ordinance, right? Because read literally, he said, you're only going to be able to enforce the vulgarity provision if it's fully subsumed within the definition of obscenity, right? So you seem to be making a distinction that Judge Dawson rejected.
Yeah, it's been rejected. We haven't appealed it. That's the way it's going to be handled going forward.
Wait, as I understand, you're making two arguments. One, if Judge Dawson's right about the statute, then we all go home.
That's right.
Right?
Correct, Your Honor.
But if Judge Dawson was wrong about the statute, then you think you can justify it under scrutiny.
There's an additional sustaining ground.
Right.
Yes.
And why, I asked your colleague this, if I thought that you can't read the statute, even considering avoidance, to equate it to obscenity, so if I believe the district court erred in that regard, why should we not go ahead and address the scrutiny issue here? Neither of you asked to be remanded to the district court. That seems a little odd, given that this is sort of such an evidentiary-based issue. But can you help me understand why, if we reject the statutory interpretation, we should plow ahead and weigh the evidence and make our own judgments about strict scrutiny?
Your Honor, we read our brief as actually giving up on the strict scrutiny point. That if it is going to be analyzed from that position, it will have to be strict scrutiny. But under Judge Dawson's
It
ruling.
will have to be strict scrutiny, or it will be?
Fail strict scrutiny.
I mean, you make.
No, it would have to be analyzed under that level. But
Right.
But it would succeed.
But it would succeed,
Yes.
right? And so the question is, why should, if I assume for a minute that I decide that strict scrutiny applies to vulgarity, because vulgarity covers things beyond obscenity, all right?
Sure.
If that were true, do you think we should address strict scrutiny? That means the appellate court? Or do you think it should go back to the district court for the district court to evaluate the arguments that you're making?
If the appellate court feels there's sufficient material in the record, with the public commentary on what was being heard, with the decibel levels and how it is restricted to
Understand,
allow him to do so within his own premises, even though it's outdoors, so that those lyrics can be clearly heard. That scientific evidence is in the Joint Appendix 34 to 38, but not to be heard on the street, then certainly this court could proceed, but more routinely, yes. It would be sent back to the district court for further factual findings.
So we could do that, but we could also send it, your view is either of those are fine,
Yes, Your Honor.
if we got to the point.
Can I?
Yeah, go ahead.
No, mine's a completely different question.
Mine is too.
Oh. So can I just ask the elephant in the room question, if this is really about people's quiet, I mean, it's like you have a whole series, so you have a couple of rationales. Actually, to make sure I've got this right. You have the quiet enjoyment rationale, right? Broadly speaking, we'll call it the quiet enjoy. That's one rationale you put forward, right?
Yes, Your Honor.
There's the protecting the children rationale.
Yes, Your Honor.
Are those the two? Is there anything else I'm missing?
The quiet enjoyment actually falls under the captive audience that you see in the Kovacs case, and I am,
Okay, but the problem, okay, so let's start with the quiet enjoyment problem that strikes me as just the fatal ballgame problem, if that's the rationale. I can blast Vanessa Carlton or Miley Cyrus or Jimmy Buffett or Bob Marley as loud as I want to, and that, or Metallica, as loud as I want to, and that doesn't violate this ordinance. But if I want to blast a whole bunch of things that are played on pop radio and certainly on Sirius and Spotify, I can't. This law draws distinctions that seem to make no sense with regard to a quiet enjoyment rationale. It is so obviously over and under inclusive with regard to that. So what is the response to that?
I'm sorry, Your Honor, the quiet enjoyment rationale is actually to the general noise ordinance, which is severable.
Okay, okay. So in other words, this particular law can't be, because it's obvious that if you just want to like let people get on with their day without being like blasted with music, the solution is simple. It's a decibel limitation on amplified sound, right?
Correct. And this one's also a decibel limitation. It
Yeah, but
is
it's a
lower
decibel
than the
limitation that
general.
only applies to some kinds of sounds.
That's correct, Your Honor. And you had asked me earlier what's one of the best cases we have that's not an FCC case. It's Shea versus Reno
Okay.
out of the Southern District of New York. That was with the Computer Decency Act, which said using the term vulgar actually has an understood meaning. It's not vague. People know what it is. It is a way to restrain something. It actually ended up finding that statute overbroad, but on the basis that it controlled adult-to-adult communication. So it didn't find it on the basis that the word vulgar was used. It says historically you could look at all the different cases that are out there and you can find a definition for it. And that definition is a level of patently offensive, explicit. And in this case, it's a captive audience rather than a quiet enjoyment.
How is it a captive audience? I mean, maybe Kovacs, but other than
Kovacs.
Kovacs, what case buys this idea that people walking along at a public street are a captive audience? Captive audience is like, it comes into my house or I'm forced to listen to it at school. It just seems deeply strange to allow a municipality to define its own streets as a captive audience.
Kovacs did it on the basis that it's true here. There are certain routes, this is a vacation town, you know at the timing of the day, you're going to have children and people heading to the beach, the ice cream shop that's next door, competing businesses located nearby were among those who complained, if you look at the joint appendix in between 44 and 57, because of the effect it had on people who had to take the street to get to where they needed to go. It's, in theory, Your Honor, of course, one could find out from someone else that this establishment exists and broadcast this music, and you could take your GPS, and you could take a route, and you could walk your children and go several blocks around and get to the ice cream shop this way. Unless, of course, it's one of the businesses next door, which can't protect itself from it. And you're a captive audience if you wish to do business there.
But so is anybody who wants to go to the courthouse.
Again, Your Honor, I think the difference there is the political message, and a courthouse is a place of government, an actual place of government. You're almost looking at a special public forum in an instance like that, which of course is not what this case is about. And it's not a political parade or anything else we're talking about being able to blast this kind of music in. But it's an inherent difference when it's the only way you can get, it's the way to the beach, it's the way elsewhere. And the broadcasts were definitely extending up to blocks away from this establishment when you look at the record. Even if this court were, of course, to strike down the vulgar, I think one thing to point out is that the code itself at 1278 has a severability provision. And so Judge Dawson's finding, hasn't been appealed regarding the obscenity matter, just as it hasn't been appealed regarding the profanity matter.
Can I go back to
Yes, sir.
the constitutional avoidance and the reading of the statute? It seems like to me there are two moves that really matter here that seem hard. One, we talked a little bit about is you got to read offensive here to mean something like lacking serious merit, right? To get under the sort of Miller obscenity definition. And maybe that's plausible, maybe it's not. But it seems like you also have to read bodily functions to somehow be limited to sexual functions, right? And not non-sexual functions, right? The back of a car where somebody's got the little Calvin and he's, doing something onto a symbol or the like, right? So that's like a bodily function. We might think of that as offensive, but we certainly wouldn't think of that as being obscene.
There
And so
are,
how would I read, if I'm trying to avoid the constitutional problem, how would I read bodily functions to be limited to sexual bodily functions?
Your Honor, I don't think you'd have to, number one.
Okay, well,
Ex-
assume for a minute that I thought I had to. Like, take it just hypothetically. Imagine that I thought in order for the definition of vulgarity here to be obscenity, that vulgarity had to be limited to sexual functions and not non-sexual bodily functions. Do you think you could read it to have that limitation be implicit? And if so, like how would I do that without, taking the blue pen out?
It's using or in its traditional sense of and or, so that it would be inclusive of the proceeding. So it would have to have.
Sex, male genitalia, female genitalia, or bodily functions?
Yes, Your Honor.
In essence, the broader term at the end of that list takes on the character of the terms that come before it?
Without the use of the comma, yes, Your Honor.
So in your view, the Calvin bumper sticker is not covered by this?
It would not be, Your Honor, because if you read the statute properly that way, yes.
So, right, so a fart song, for example, let's assume for a minute it's offensive in some sense, your view is that would not, we could interpret this statute in a manner to not include such a song because it lacks the sex or genitalia sort of theme.
Yes, Your Honor. And it also, that would fall under offensive as well. It's just, under today's contemporary standards, people might not like it very much, might think it's gross, but it doesn't rise to the level of being offensive.
Right.
Can I ask you the flip side of a question that the chief asked your colleague, which is, why do you care? In other words, if you're content to let Judge Dawson's weird atextual reading that says literally vulgar means nothing other than what obscene means, but you're allowed to enforce obscene, why do you care why does it matter to you whether we enjoin vulgar or not if you're content to just let vulgar be the same thing as obscene? Because both of them run to the world in which only obscene speech can be prosecuted.
The city believes,
Unless it's the chill, which is the reason, your friends on the other side say the reason you care is the chill, which is the First Amendment problem. So what's the reason you care that's not the chill?
the city believes it is subsumed on a regular reading within obscenity, and frankly gives a better definition of what obscene conduct is to the typical citizen.
Do you have anything else, Mr. Mons?
Your Honor, I believe that covers everything I had. Thank you very much, Your Honor.
You're welcome. I have to say, I think my two colleagues are culturally much more sensitive to things. I still don't know what was it a Calvin sticker? Is that what you? Mm-hmm. We'll have to take that one off.
I'll tell you during conference.
Yeah. We'll have to take that one offline, I
I'm
guess.
confident the colleagues here won't object to including that into the unofficial record.
Ms. McPhail, go ahead.
Thank you. Yeah, I'd just like to start kind of by addressing, again, Judge Richardson's question about, well, if the term vulgar still remains in the ordinance, kind of what's the point here? In the city's argument, they kind of hedged a little bit, but functionally asserted that the vulgarity provision does have some sort of independent value, or at least could have some sort of independent value.
I think the way he phrased it at the end was it just gives more specific meaning to the broader term of obscene. Is that a problem?
Well, I think that it's inaccurate that it gives a more specific reading. It's actually much, much more general. But, earlier in the argument, there was some argumentation about why vulgarity could theoretically have, sustain challenge. And the inclusion and the continued inclusion of the vulgarity provision, is problematic in this case, particularly given the background.
Why wouldn't we do this, why isn't this sort of interpretation like the tangible objects, Yates, right? So we could read bodily functions, this is maybe the piece I'm most hung up on. We could read bodily functions, like we could read tangible objects really broadly, and yet in Yates, the court says, like, whatever you want to think, a fish isn't a tangible object. And so maybe we could say the same thing here, that the nature of the list that precedes it helps us inform the scope of bodily functions, and sort of add on to that, like, maybe I think that wouldn't work in a normal case, but then I get to, like, put the weight on the side of the scale that says, and I get to avoid a constitutional question if I do so. Why not Yates? Why not, like, read it that way?
Well, I think the list is explicit and offensive reference to sex, male genitalia, female genitalia, or bodily functions. And as I take the city's argument, they're saying that sex specifically refers to bodily functions and kind of suggests a more narrow interpretation than what the text itself of the ordinance would
Sort of
suggest.
all three at some level, right? I mean, I get, again, probably not enough if I'm doing this like de novo, but I got a constitutional avoidance sort of overlay that tells me, like, can I plausibly read it that way? And, Yates tells me that I can do a lot of work by the nature of what comes before it.
I think Yates does stand for that proposition, but I don't think that proposition gets you there here. It's just an implausible reading of vulgarity, and I just don't think that it gets you that far in this particular case on these facts.
Well, I guess the thing I'm just still, so I mentioned this about Judge Dawson. If we supply a limiting construction of this statute, is that binding on, like, literally anyone? Is a federal court's limiting construction of a state statute binding on anyone on earth? Except maybe us, I guess, in a future case.
I would think that it would certainly be authority in a case where someone was prosecuted under the ordinance, but was asserting a First Amendment defense.
They'd have like a good faith defense or something. I mean, I guess I just keep coming back to the South Carolina courts don't have to agree with us what their statutes mean, right?
Yes.
They could say, with all due respect to Judge Dawson, with all due respect to the Fourth Circuit, that is not what the statute says. What the statute says is blank.
Yes, certainly. But of course, they would still have to, any statute would still have to comply, and any enforcement
Well, sure,
of
but
any statute.
then we have in some ways with the whole thing that your lawsuit is trying to avoid, which is a person being prosecuted in state court who has to litigate their First Amendment claim defensively.
Exactly. Yes, that's exactly the problem. And fixing it on the back end is just insufficient in this crucial First Amendment area where protected speech has been chilled and in fact was intended to be chilled by the city.
Wouldn't that be true in any avoidance case, right? So maybe the point of that is, like, our federalist system means you got to bring the case here and you got to bring it in state court if you're really concerned about getting prosecuted for something that's not obscenity, right? But yet that would mean that we could never do constitutional avoidance involving a state statute.
I don't
We
think
couldn't
that
rely on it, right?
the First Amendment does provide specific considerations here that wouldn't necessarily be the case in other statutes. The First Amendment analysis requires extra care to avoid this fear that folks will chill themselves, that will censor themselves from, protected speech. Because the core of the issue here isn't, well, what do we do on the back end? What happens when there's an enforcement action? But rather what people won't say at all in the beginning.
Thank you, Ms. McPhail. I want to thank both counsel for their fine arguments before us. We'll come down and greet you and take a brief recess and then move on to our final case. Our third and final case is United States versus Ferguson, 23-4347. Mr. Lorello.
Thank you, sir. May it please the court, Chief Justice Diaz and your honors, we are here today on behalf of Mr. Ferguson asking the court to overturn his conviction by finding that the trial court erred by abusing its discretion in allowing the entirety of a recorded forensic interview to be submitted to the jury as a prior consistent statement, and that such error was not harmless because that particular forensic interview, the entire recording of it, was not a prior consistent statement. There were portions within that recorded interview which were entirely new and which were designed in order to build up the rapport and the credibility of the witness, and these were not statements that the witness had not
Can
previously.
I just ask you the question that sort of leapt into my head when I watched the first, say, 7 minutes of this video? I'm not sure what, if any, statements by either the child or the interviewer in the entire first 7 minutes of this video are even plausibly being offered to prove the truth of the matter asserted.
I don't think that they necessarily were one.
Well, then
way.
they're not hearsay.
Well, then they're not, but they're not relevant though, and
But that's not the, you didn't tell us that the district court abused its discretion by concluding it was irrelevant. You said the district court abused its discretion by concluding it wasn't hearsay.
I think that the fact that the entirety of the interview, though, was admitted was the initial issue with the court, though, and that we did argue that.
Was the entirety admitted? I thought the court got rid of a portion of it.
There was a portion which was redacted, which dealt with an additional.
Victim. Yeah.
Additional victim or an additional allegation, which
So
was.
it's not, you keep saying the entire, I mean, I just think it wasn't the entirety. The district court actually sort of seemed to carefully go through this and sort of decide, yes, this, not that.
Yes, sir, and to be clear, if I ever refer to it as an entirety, I am referring to the entire recording with that particular portion having been redacted as well. Our objection to it was that not only just the initial 7 or 9 minutes of it, which Your Honor stated in regards to that rapport building, but there are additional portions within the remaining 30 minutes of the interview which were also not prior consistent statements. There were portions where the child is talking about things about her household, her family, her relationships.
Why are any of those being offered to prove the truth of the matter asserted?
I think that just by being able to present them to the jury, it put the jury.
But you're yada, yada, yada-ing literally the definition of hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted, which means any statement that is not being offered to prove the truth of the matter asserted is literally not hearsay.
The issue, though, was that I can see that there are certain portions within there which were probably not.
Well, let me flip this around. Can you identify one statement in this that is actually being offered to prove the truth of the matter asserted?
In regards to the portions which we had objected to?
Yes.
I think that.
What's the strongest one of these statements that's being offered to prove the truth of the matter asserted in the statement?
Unfortunately, I don't think I can identify one particular ones within there. I think the larger objection was to the entirety of the interview, not solely on hearsay grounds, but also on relevance grounds. I think that when you're introducing a recorded statement such as that, you're putting the jury in a position where they're being allowed to repeat and rehear the testimony of the witness over and over and over and over and over again.
But that's a 401, 403 objection, not an 803, not an 801 objection.
Yes, sir.
Okay.
The larger issue was that when those statements were being able to be introduced.
Do you think that a forensic interviewer, when testifying, can describe the process of a forensic interview? So in other words, I conducted the forensic interview, and here's the process by which forensic interviews are conducted?
I think that they can. I think the purpose of.
And they can because that's like relevant to the jury, right?
It's relevant in terms of describing to the jury what is a forensic interview.
Right.
Because a forensic interview is, of course, a technical term, and a juror needs to be able to understand what a forensic interview is. And that includes.
So help me understand just on the relevance point. So if they can describe it, because we all agree that that's relevant, why wouldn't it be relevant to like actually see the process, right? Hey, here's my little intro, here are the rules, right? Now, how about describe for me something that's totally irrelevant, just to like show that, you can remember facts and you can describe things. And then let me ask you the things that matter about abuse.
Yes, sir. Because there's a difference between the witness who conducted the forensic interview describing the process, describing what a forensic interview is, describing the protocol that they're using in order to conduct the interview, and then subsequently admitting the entirety of that.
And what is the difference between those two? It's that the video is just more powerful?
It is more powerful, particularly when it's video recorded and it's allowed to be introduced to the jury. The example that I would give the court is whether
Is there any other difference other than it just being more impactful?
it's incredibly persuasive to a jury to be able to allow a witness rather on.
Anything else? Because all of those, like, seem to go to a question of 403 balancing, which I totally get, right? But they don't go to a 401 relevance standard, right? We're seeming to agree it's relevant. Maybe it's improper under 403, and we could have that debate, but it seems like obvious to me that it's relevant. There might be a 403 balancing inquiry because it is powerful and persuasive, or maybe it is. I'm not sure how powerful and persuasive the first 8 minutes here were, but that's a 403 question, not a 401 question and not an 801 question.
I would agree that it's relevant for the witness to, just to make sure that I'm fully understanding Your Honor's statement. It's relevant in the sense that the witness can testify about what the process is, why they do it, why they ask those types of questions. What's not relevant and what should not be admissible is the actual statements itself. And the example that I would give the court is whether you're a prosecutor or a defense attorney, if you're putting on a witness, whether a criminal case or a civil case, you're going to want to have the opportunity to have that witness ingratiate himself with the jury by talking about his background, his life, what they've done for a living, their history, things like that. That's objectionable, and that's not something that's allowed to be introduced because it bolsters the credibility of the witness before they ever begin to testify.
I'm sorry, you're not allowed to introduce a witness?
You're allowed to ask some very basic questions. What do you do for a living? Are you married? How old are you? Things like that. But you certainly can't go on for 8, 9, 10, 15, 20 minutes having them go on about who they are as a person, things that are not relevant.
And you think you can't do that because you think it's not relevant, or do you think that's just within the trial court's discretion to move things along? If it's not relevant, you can't ask about it at all. That means that, like, the person has to get up there and maybe they get to say, do they get to say their name?
They get to say their name.
And then what about where they work?
They get to say those types of things. But
Why? In many cases, in many cases, I struggle to see, if we're defining relevance at all strictly, in many cases, I struggle to see any relevance whatsoever to the witness's job. Like, if we're going to apply a real strict definition of relevance, most witnesses, I don't know why I care what your job is.
I think in practice, if the other side were to stand up and object to that and make a relevance objection, it likely should be sustained. It's really not.
I thought you were going to say in practice it would almost certainly be overruled.
Right, of course it would be,
I think
because part of what is relevant is a jury's ability to evaluate the credibility of the witness.
Yes, sir.
Right? It's the reason that the witness takes the oath in front of the jury.
Yes, sir.
We could do that outside the courtroom, right? But we have the witness take the oath in front of the jury,
Yes, sir.
right? We have them introduce themselves because part of the jury's job is to evaluate their credibility. And yes, you can go too far on it, but I would have thought that it's well accepted that to evaluate a witness's credibility, you get the opportunity to introduce them in some degree to the jury.
You do to a very limited degree. And when I said that it should be sustained, I think, again, in practice, it would never be sustained. I think the court would allow those types of questions to ask a witness what their job is, how old they are, things of that nature. I don't think a court would allow the witness to testify at length, 5, 10, 15, 20 minutes, about their interests, their background, what they like to do, things that would necessarily make a jury like them more. That would be bolstering the witness. And in this particular case, not only was it introduced to the jury through the video, but then the video was admitted to the jury. And so the jury was allowed to go back in the jury room and watch it over and over and over again. How many times, we don't know. But what that does is it allows the jury to improperly focus more and more on the rapport building and the credibility when that should not have been admitted in the first place.
I have a couple of questions about preservation along those lines. Did you ever object? So you just distinguish between showing the video to the jury and giving the video to the jury. Did you ever object to that?
I think it was preserved by our general objection to the admission of it in the first place. Whether it's shown to the jury once.
Oh, well, that was different. You could say, Judge, I don't think the jury should see this at all. But if you disagree with us about that, you should not let them bring it back to you should not let them have act. I mean, those strike me as separate objections.
Respectfully, Your Honor, I think that it was preserved by the objection to it being introduced. And that was our objection.
And I want to ask you this on your main argument in case you need to come back to it. I definitely get that you objected to what I'll call the Korea stuff as 403. You definitely made a 403 objection to that, but that's the part that, as Judge Richardson pointed out, the trial court excluded. Could you give me what your best record cite for the proposition that you preserved a 401, 403 objection to the portions of the video other than the stuff that the district court excluded?
In regards to.
401, 403, not a hearsay objection, a 401, 403 objection.
Judge, I think that the language of our objection, and if you recall from the joint appendix, I believe it started on page 261, that the language of our objection talked about all of those particular issues. Now, I don't recall specifically whether or not it was specifically addressed as a relevance objection or a 401 objection, but what we did.
Not relevant to 401, but I guess what I want to make sure is that it was made as not a hearsay objection.
I think when you look through the language of our objection in the joint appendix, I think it's very clear that that was an issue that was being presented to the court, and that was something that he was deciding on as well, because our objection was that the prior statements about the rapport building and things of that nature were not something that the jury needed to decide, or not something that was relevant for them to be able to consider for those reasons, because it was not a prior consistent statement, it was rapport building. And rapport building was not relevant. That was something that was utilized in order to bolster the credibility of the
But I
witness.
thought you said earlier that some rapport building is relevant.
I think that what is relevant is some rapport building from the witness on the actual witness stand, not being introduced as a prior consistent statement, which was the rationale and the basis offered by the government in order to introduce that video in the first place. So you can have a.
But you agree the forensic interviewer can, like, describe all
Yes,
of that?
absolutely. That the forensic interviewer can describe the protocol of which she uses in
But if
order
it's-
to.
help me understand. If it's relevant there, why is it relevant to hear about it secondhand, but not relevant to hear about it in firsthand?
Because the difference would be the same as a detective explaining to the jury how it is they go about building rapport in an interrogation technique. The types of questions that they would ask in order to develop that relationship with the suspect. They're able to talk about the protocol and what they've been trained to do and how they're
And if the
trained.
defendant thought he was manipulated, right, he might want to show that.
Correct.
Right? So, but it'd be relevant. I totally get the rest of the stuff, but it still would be relevant if you think that rapport building was improper in some way or dishonest, right? The defendant might want to show that because a reasonable fact finder would want to see how that process began.
Correct. But the problem in this particular case is that it was offered and it was introduced as a prior consistent statement. And it was not a prior consistent statement. It was included as part of that. And the government, I think, was very candid.
Well, hold on. You agreed that some of it was introduced as a prior consistency.
Yes.
No, you're not, but at least a portion of this interview was unquestionably introduced as a prior consistency.
Absolutely.
Okay.
I think there are clearly portions within
When
there.
the
and I
victim
believe-
is describing this stuff that she testified to in her own testimony, and the defense argued she was not being truthful, and then we introduce a previous statement of the victim recounting the same events, that's a prior consistent statement, right?
Correct. And if your honors review the cross-examination of Jane Doe in this particular case, I don't believe we actually even impeached her at any point with prior inconsistent statements. And so we.
No, but the whole defense was she's
Correct. And we-
lying or mistaken.
And we conceded to Chief Judge Davis that there were portions which would be admissible as a prior consistent statement.
Can you just give me your take on what consistent means? I mean, we've said consistent with means this idea of congruity or compatibility, right? The sort of like, it's a general consistency. And so that suggests that you can gap fill and it doesn't have to be exactly what was said, right? Consistent with is broader than was repeated on the stand, right? But do you have a sense of how you would draw this line of what is a consistent statement as opposed to an inconsistent statement? Those seem like just the two sides of the coin here, but where you think that line is?
Well, it's going to be a blurry line, no question about that. But I think the best way to describe it is whether or not there was ever any actual testimony on the witness stand which is in any way related to what is also being introduced as a quote-unquote prior consistent statement. I think one way that the Supreme Court of the United States described it in Williamson, which is the supplemental authority which we presented in regards to the rule against, or the statements against penal interest, was whether or not the statements are collateral or not. And I think that's one way to look at it. Many of the statements of Jane Doe in the recorded forensic interview were entirely collateral to what was being offered and what was being presented as a prior consistent statement.
Maybe, but the other way of thinking about them is they're not collateral at all because the question here is fundamentally her credibility. And if we're evaluating her credibility, we had the forensic interviewer that talked about why this part of the interview is important for the interviewer to evaluate her credibility, right? So we've got evidence here that these types of information is like highly relevant to a witness's credibility. And the whole reason that this is going in is because the credibility is what is at issue.
Yes, sir. May I answer your question?
Please.
I think what's important is that the rule allowing the introduction of a prior consistent statement was not fashioned so broadly as just to say prior statements which support the credibility of a witness shall be introduced. It specifically allows for prior consistent statements. And so while if there are other statements within that particular interview which might go towards her credibility or might go towards whether or not she's being truthful or not, because they are not prior consistent statements, they should not have been introduced. Thank you.
Thank you, counsel. Ms. Yusi?
Thank you. Good morning, Your Honors. May it please the court, I'm Elizabeth Yusi for the government. How the government has read the argument at least in the lower court and especially in the appellant's brief is that this is a 403 argument about whether or not this omission of these were unduly prejudicial. And as this court is aware, the Fourth Circuit gives a wide discretion to lower courts in what they can admit as, in this case, a prior consistent statement. And we believe that it was entirely proper under 401, 403, and 801, which was what the court was considering as well, though it did make a 403 assessment of this. It was not
just what strikes me as the most genuinely perplexing question of the hearsay issue. I really expected that when I opened up the government's brief, I was going to see an argument that the vast majority of the statements to which he objects were obviously not being offered to prove the truth of the matter asserted, and thus don't meet the definition of hearsay in the first place. I don't see that argument anywhere in the government's brief, and I don't know what I'm supposed to do with that.
Your Honor, I think in general, whether we stated it explicitly or not, it's...
No, your whole argument is that these are prior consistent statements, which is like part of the, like, there's this weird thing about the Federal Rules of Evidence. They define hearsay, we've repeated the definition, and then they just declare that certain things that obviously meet that definition are not hearsay, notwithstanding the fact that they obviously do. But at least it strikes me, those are different arguments. Like, this does not meet the definition of hearsay set out in 801A. Strikes me as different from an argument that it does meet the definition of hearsay set out in 801A, but it is then excluded by the carve-outs under 801D and the other provisions that do that. Those strike me as different arguments.
And I think they are, Your Honor, I agree with you, and I do not think, I think that the rapport building that is being objected to here, it was all contextual. So in terms of what was going to be a prior consistent statement, we were focused on what she actually said about what she testified to, what Jane Doe testified to in the court. And so the 7 minutes or the 9 minutes of the 45-minute interview, it was all context. And that, as this court
I understand, but his question is, I think, a little different, which is, why did the government not argue before us or before the district court that at least large portions, if not all of that, is not hearsay because it's not being offered for the truth of the matter asserted, right? If you do a hearsay case, we start with the premise that it has to fall within the bucket that, out-of-court statement offered for the out-of-court statement offered for the truth of the matter asserted. And then if so, we have a number of what we'll sort of broadly call exceptions. Some of them are technical exceptions, some of them are just, nominal exceptions. And that sort of like legal predicate was not the argument that you made in the district court and you not made here. And so the question is, what do we do with that? Like, is that a forfeiture on behalf of the government such that we have to assume that these were offered for the truth of the matter asserted? Like, what are we supposed to do given the government failed to make what strikes me as the most obviously correct argument?
Your Honor, I don't think that we forfeited it. I think that we were talking around it and talking about it within that it was such a non-issue in terms of what she likes for cereal, what's her dog's name, that sort of thing. was so obvious that we were not giving that as anything, and for the truth of the matter, whether or not we said it, under, that it was not hearsay, that was on us. However, how we talked about it, it was a non-issue. And it was so obvious that these things were not part of the elements of the crimes. These were not part of the crux of the evidence that we were presenting to the judge and to the jury, that it never came up as, of course, it was just an obvious thing, Your Honors. And, as what we did, and as the court pointed out, we did bring in why there's no confusion as to the jury as to why they're seeing this rapport building, because the agent, the forensic interviewer, explained why they're doing this. And it's all about whether or not we were allowed to rehabilitate this child's credibility using a prior consistent statement. And this, as a forensic interview, the entire statement, it is important, other than what we excised, and we agreed that was not relevant and unduly prejudicial, but it is a statement in its entirety.
Do you think it's different because it's a kid? So in other words, do you think if we had such an interview that was not from a child, is its relevance different there, or do you think that would merely go to sort of the 403 balancing, that we might think an adult in this situation, this type of rapport building and sort of intro might still be relevant, but maybe the 403 analysis looks different?
I think that a court in every trial situation, that they're evaluating each witness individually. And a child that's a witness is going to be evaluated as a child, as part of as their innate characteristics. And a court's generally going to allow, whether you're an adult or a child, these introductory witnesses. If you have a very nervous witness, even if it was an adult, the court's going to give you more leeway in getting them comfortable or able to answer questions, verbally and that sort of thing.
Why do you think, so we talked to your colleague a little bit about this, why do you think the intro, every witness I've ever seen put on, right? They spend a couple of minutes, and the judge will occasionally look at you if you go too long, but you spend a couple of minutes sort of introducing the person. Why do you think that's appropriate under Rule 401? Why is it relevant?
I think it's relevant to whether or not this person is able to speak in English and understand the language and understand your questions, and it's all about the credibility. It is relevant to the credibility of this witness. Are they educated? Are they highly educated? Do they have issues in school? Do they have memory issues? You can get into some pretty big issues just as rapport building / this is who you're going to be hearing from, jury. This is the person that you're going to have to make a credibility determination from. And so I do think it's highly relevant in terms of that, whether or not the actual words have anything to do with your elements that you're proving in that case. So,
So you think, in your view, when the trial court judge says, that's enough, counsel, let's get to it, that's sort of in effect a 403 analysis. Like you've done enough of this, we've introduced enough of this witness, it's time to move on? That's effectively a sort of implicit 403 judgment?
Absolutely, Your Honor, that you're going into. It's 403, but it's also 401. Like, all right, we've established this person understands your questions. We've established they understand right from wrong, or that, whatever the situation is cognitively. And let's go on to the meat of the matter. So, it's efficiency, it's relevance, it's prejudice, it's everything that the court does when they're controlling a trial. So, and Your Honors, I do want to address the harmlessness error. While it was only mentioned briefly, I think in the last sentence of the appellant's thing, that this was not harmless without any explanation, and there was no reply brief, so I'm not sure what their argument will be about harmlessness. But as the court already knows, we went through this rapport building and the purpose of it, and there was no objection at all when we had Agent Guattardi talking about it up there. Judge Davis was meticulous in his decision-making, citing case law, doing a 403 analysis, and he determined it was not overly prejudicial. And when it's only 9 minutes of a 45-minute interview, 36 minutes that were not objected to, which had And when I think what they said in their brief, they were worried about the jury seeing the demeanor, the actions, the movement of the 11-year-old on this tape. We had 36 minutes of her demeanor, her actions and movement that were not objected to at all. And they highlighted it again after it was played in the length.
Well, and also that, to the extent that is a form of prejudice, that would only work as a 401, 403 argument, right? Because from a hearsay perspective, as long as you turned the sound all the way down or scrambled her words, from a hearsay perspective, you can show those 9 minutes, right?
Correct, Your Honor. Yes, you absolutely can. And they also allowed, without objection, pictures of Jane Doe from when she was 11 years old, because we weren't sure if we were going to, we didn't have a preliminary hearing about whether or not we were going to show this video. And so we were, without objection, we admitted pictures of her as an 11-year-old, which are in the supplemental appendix. And there was no improper bolstering. We did not ask the interviewer ever, did you believe her? Do you think she was telling the truth based on your experience? Anything like that. This was absolutely let in, first of all, appropriately under 801. And there was also other corroborating evidence. We had an entire second victim, which is not talked about in the appellant's brief at all, who was similar in age, had a mom who was romantically involved with the defendant, trusted the defendant like a father. He did a spontaneous grabbing of the genitalias and breasts. Those girls didn't know each other at all, did not know each other of accusations when we found the second victim. And so in terms of corroborating evidence, even outside of those 9 minutes, Your Honors, I do believe any error would be harmless, though we don't believe there was error.
Thank you, Ms. Juicy.
Thank you.
Thank you, Your Honors. Judge Haydens, you indicated to me, or you had asked me if I could point to a part of the joint appendix or the record where I had preserved a relevancy objection, and it would be on page 266 going into 267, where we explicitly told the court that likewise with the rapport building, we think there's a relevancy issue here. And I think certainly if the government had focused more on whether or not it was or was not hearsay, then I think we likely would have doubled down significantly on that particular avenue.
Can you tell me, to the extent you know, how this came up? It seems like there's some discussion, and then the judge says, email me some cases, and y'all send them at night, but there wasn't like argument about it. And then the next day, right before the agent goes on, there's this discussion from 261 to 267 or 8 or whatever it is.
That's correct. If I recall correctly, we had raised it as an issue the prior evening, and we had addressed it with the court as something that we needed to explore and would be asking the court to consider prior to Agent Guattardi's testimony, which allowed the court the opportunity for us to email some of the case law, which the court subsequently ruled upon. Specifically addressing the harmless error issue, I think.
But there wasn't a written, I'm not saying there should have been, it's not, but there wasn't a written motion that was filed. This is all sort of part of the oral discussions that
Yes,
are
sir.
going on.
Yes, sir, correct. In regards to the harmless error, I think when you look at the standard for harmless error, you have to determine whether or not it would have had a significant impact, or whether or not the jury would have been swayed by the introduction or the lack of introduction of that particular portion of the interview. And I think the best evidence of that is that was at one point a hung jury, and that an Allen charge had to be read for the jury, and they had to go back and deliberate it. And after that Allen charge was read, they deliberated for an additional 1.5 hours, according to the record, before finally returning their verdict.
We have no idea why they were hung, though, right?
We do not, and certainly we can't introduce ourselves into the jury and question why they hung or what issues they might have had, but I think that that's evidence that this was not an overwhelming case in regards to.
But that can't be right, because it would seem like that would be an argument that literally any evidentiary error the district court made was not harmless, and you're not asking us to adopt that proposition.
I'm not, but I'm asking the court to consider that in totality with the other evidence, that there was not significant corroboration with this particular victim, Jane Doe, that there was no type of forensic evidence, digital forensic evidence, things of that nature. And so we can't say one way or the other whether or not that video, what impact it had on the jury. It's important because, when we talk about the jurors being able to judge the credibility of the witness, that's when they're on the witness stand. And that's when the defense attorneys have an opportunity to cross-examine them. And usually that's the only opportunity that the jurors get in order to observe the witness. They hear the testimony, they take notes, they go back in the jury room, and they deliberate.
And just to confirm, I think I've worked through and the reason you have not raised any sort of Sixth Amendment challenge is because the victim testified, which means there's no Crawford problem at that point.
Correct. There is no Crawford problem. And in fact, for this particular introduction of a forensic interview, there are statutes in place at the state level, the Commonwealth of Virginia and other states as well, which allow the introduction of the forensic interview, and Crawford problems are raised in those particular cases if
Well,
the
if the victim
child
doesn't-
does not testify.
Right.
Here, the child testified, we cross-examined. We couldn't cross-examine the video, though. And the video was played after she testified. But what's important is that we don't know how many times the jury watched the video. We don't know how many times they played it, how many times they looked at that 7, 9, 10 minutes of rapport building and saw a little girl who was talking about these types of things, serial dogs, things of that nature, and what impact it had on them when they're then looking at the rest of the video.
You just said that, you just noted that the video is played after the victim testified. Would you have been able to recall the victim? If something in the video was something that you wanted to explore with the victim, you presumably could have recalled the victim, right?
I think the victim may have been released at that point. I would have to go back and look at the record to determine whether or not she was still on call or not.
But she was only released with your consent.
Correct. And certainly at that point, the ruling had not been issued in regards to whether or not the forensic interview was going to be played in its entirety, absent the portion which we previously discussed.
But counsel would not have been surprised that the forensic interview might be played or might not be played.
I think we were surprised, and particularly in regards to the fact that there is no provision under federal law that allows for the entirety of a forensic interview, a quote-unquote tender years exception, to be introduced. And so certainly we would not be surprised that portions of the video may have been introduced as a prior consistent statement. But as you can tell from the case law which we presented overnight to the court and the advocacy which we had in trying to keep those portions out, it was important to us because anytime a jury has an opportunity to hear the witness over and over and over again, even those portions in the beginning, particularly when you're talking about a very young girl, you just don't know what type of impact that would have had upon them in terms of how they viewed her credibility as a witness, both when they saw her on the witness stand and the remaining of the video itself. And for those reasons, we do ask the court to find that the trial court erred and that it was not harmless.
Thank you, Mr. Lorello. I want to thank both counsel for their fine arguments. We will take the matter under advisement and adjourn until tomorrow morning. Come down and greet you before.
Honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank you so much.
Thanks for having me.
Thanks very much.